Good afternoon, everybody. I'm Mike Yablonowitz, CEO of Snapscale, and I'm thrilled to kick off this important conversation about HIPAA compliance and the impact of the 21st Century Cures Act on healthcare providers. At Snapscale, we specialize in HIPAA-compliant outsourced staffing solutions for healthcare providers. Our mission is to ensure that doctors and clinics receive top-tier administrative and clinical support while staying fully compliant with industry regulations. Compliance isn't just about avoiding penalties. It's about safeguarding patient trust, streamlining operations, and ultimately improving the quality of patient care. Before we dive in, I'd like to introduce today's host, Nathan Bush, who's our Senior Vice President of Sales and Marketing at Snapscale. Nathan has extensive experience working with healthcare organizations, helping them optimize operations while ensuring compliance. He'll be leading today's discussion, guiding us through key updates and challenges facing providers. In addition, he is the author of the Caesar Method, a strategic growth framework designed to help businesses rapidly scale through a 6-step process focused on trust, client acquisition, and long-term success. This webinar is designed to be interactive, more like a town hall discussion. We'll ask questions, our panelists will share insights, and most importantly, you will have time to ask your own questions as well. So we encourage you to participate, engage, and get the answers you need, for this webinar is for you. And today we're privileged to have an incredible group of experts joining us. First off, Matt Darjany from Digital Compliance. Matthew is a recognized expert in HIPAA compliance and data security. He helps organizations navigate the complexities of protecting patient information. Digital Compliance specializes in making compliance simple and effective so that healthcare providers can focus on patient care. Today, Matthew will walk us through recent HIPAA updates, what's changing, and what steps you should be taking now. Experts Zak Kennedy and Fagras from InterCorp PVT is here too. InterCorp PVT provides cost-effective solutions to help doctors and clinics comply with the 21st Century Cures Act. The Cures Act has completely changed how patient data is accessed, shared, and protected. Zak and Gordon will explain what this means for your practice, what steps you need to take, and how their solutions can make compliance easier and more affordable. The 21st Century Cures Act is a game changer. It aims to improve interoperability and give patients better access to their healthcare data. But with these advancements comes new challenges, including how to protect patient information, avoid information blocking penalties, and implement the right compliance measures. That's why this conversation is so important. Compliance isn't just a legal requirement. It's the foundation of trust, efficiency, and again, better patient care. Whether you're running a small clinic or a large healthcare system, the actions you take now will determine how smoothly your organization operates in the future. So with that said, I'll turn it over to our very own Nathan Bush to kick things off. Nathan, take it away.
Yeah, great. Thanks, Mike. Totally appreciate it. And thanks, guys, for joining us. It's exciting to have you here. Thanks for being a part of the show. Now, you guys to come off mute whenever you're going to have a conversation. Go back on mute. That way we don't have any echoes or feedbacks on the show. That's just been introduced here. But I want to be excited for all of our guests that have joined us online. We had over 200 people register for this HIPAA compliance webinar. And so, guys, what that really tells us and tells the panelists is there's a lot of interest around the changes in laws and things that are going on right now. And it's up to you. It's up to you to ask the questions and be a part of the conversation right now so you can learn everything that you need. You have the top tier people in the entire industry when it comes to HIPAA. And so now's the time to ask your question if you really do have a question. You can put it in the chat anywhere along the line. We might answer it throughout the show, and then we might also answer it in the Q&A section down at the end. But if you have a question, go ahead and throw it in the chat. I do want to start off, though, this conversation by talking about the 4 levels right now of HIPAA compliance. And so I used to run a healthcare practice. I had 47 different locations with hearing clinics. And here's what I know is I went across people in the industry. Here's what I found. Maybe this is you in the physical therapy industry. Maybe you're a reactive clinic. You only address HIPAA problems when they come up. Okay, that might be the case, and that might be you. You might also be this one, basic compliance. If this is your level, that's okay. Today's show is going to also speak directly to you. If you just check the boxes and you do it most of the time, that's okay. Today, we're going to learn, though, maybe how to become a little bit more, this show might help move you to a little bit more proactive compliance, where you'll be able to take HIPAA seriously and have systems in place and some resources and know where to go and who to talk to in order to fix some of the HIPAA challenges that you have. Or maybe you're this last one, like our organization at Snapscale, which is a culturally driven compliant organization. This is where HIPAA becomes part of your identity, and it's not just a requirement. So that's what today's show is going to, if you're any of these 4 levels, guys, this show is going to be 100% for you. I want to get in and start with Matt Darjany. Matt, if you come off mute, I'd love to talk to you just a little bit and introduce yourself and talk a little bit about what is HIPAA. Like, I know that you're very knowledgeable about this subject, but at the basic level, like if I'm a third grader, what is HIPAA?
Yeah, thanks for having us on. So HIPAA is the Health Insurance Portability and Accessibility Act, right? It is, in the industry, it's thought of as the base level series, the minimum federal floor for protecting patient information. And it's really encompassed for most, I would.
Whoa.
Did you lose me? Did you lose me?
I lost you for a second. You said it's really encompassed, and then we lost you for a second.
Yeah, I feel shunned. You hurt my feelings. So what it's considered for 95 to 99% of the industry, it comes down to 2 rules, right? The privacy rule and the security rule. The privacy rule, and by the way, as an unplanned aside, it's very helpful to just become sort of navigable, competent at engaging online with the HHS.gov website. You can do simple searches for things like privacy rule and security rule. They are the 2 fundamental base plates of determining what my responsibilities are as a business or a care provider that handles patient information, what my responsibilities are, and the best practices for enacting them. Okay, in our profession, we're a bunch of administrative goons, and we sort of parse these rules. The privacy rule is where a practice or a business begins. What is the difference between privacy and security? Privacy typically codified in our policies and procedures, an actual mandate that we have HIPAA-specific policies and procedures, regardless of what our organizational procedures look like. They tell us who has access, who has the right of access, and what they have access to when it comes to protected health information. The security rule, which is sometimes mistaken for a series of network and IT rules, is really the set of rules that lays out what are our practices for protecting our information. So if the privacy rule says, here's our policy on HIPAA, how we train our staff, how we train ourselves, what our approaches to HIPAA are, how do we meet the HHS standards. The security rule, our policies with regard to the security rule tell us exactly what steps we take to meet those minimum standards of protection. Okay, so at a base plate, who has access, what they can access, how the information is used, how we have captured patient consent, and then the security rule covers specifically what do we do to protect that.
Yeah, that's fantastic, Matt. Thank you for that explanation of HIPAA and the security rules. I totally understand that HIPAA is a deep subject. And so there's no way that we're going to be able to cover everything inside of an hour today, but we will cover a lot. I'd like to introduce Zak. Zak, if you come off mute and share a little bit about, kind of piggyback on what Matt was talking about on HIPAA, but help us understand a little bit about the Cures.
Yeah, absolutely. And thank you very much. So the Cures Act really is kind of a new age extension of HIPAA. Specifically, the Cures Act takes it a little bit further. It's a modernization of the standards to catch up with the regulations. And the Cures Act builds on HIPAA and focuses more on the patient and then the seamless data exchange. The Cures Act really pushes data interoperability. And the whole point behind that is to increase the effectiveness of treatments. But where the Cures Act goes a little bit further is into sections such as segmentation of data. So SDOH data and mental health, substance abuse, reproductive health, for example. Under the Cures Act, physicians are required to allow their patients to restrict the sharing of that data. The Cures Act also addresses data blocking. And so what we're seeing right now is there's been challenges in terms of enforcing the Cures Act because it's been relatively nebulous from the federal standpoint is who's responsible to comply with the Cures Act. Is it the IT developers? Is it the physician? Is it different vendors? Who's supposed to do this? There's been a lot of finger pointing. And as we get into today's webinar, what you're going to see is these updates to whether it be TEFCA or HIPAA or inclusion of additional security protocols, multi-factor authentication, patient consent, et cetera, are all moving HIPAA a little bit closer to where the Cures Act is putting more power in the hands of the patients. And really, it's about patient engagement and capturing all of the data that we're now seeing as IoT data. Think Fitbits, think phone usership, your location on your different devices. All of this now, because you can gather it, is all falling into healthcare records in one way or another. And that's where the Cures Act comes in. So again, I think what we're going to see coming right down to it with enforcement, they're going to do this through HIPAA. And then in terms of who's going to be responsible for providing the services like patient consent, like different interoperability protocols, is probably going to come down and be adjudicated in the courts at some point down the line here, even though the Department of Justice is responsible for administering, whether it be fines or penalties or adjudications in that respect. There does need to be some clarity of who is responsible. So what we're here to do is really help all of our viewers today be as in compliance as you possibly can through different tools and strategies.
Yeah. And Gordon, we'll get to you in just 1 second. I do want to make a promise to everybody. Today, you're going to learn some practical tools about HIPAA. Okay. I'm going to ask some questions to these experts that will give you some practical tools, things you can implement right away. The second promise I'm going to make to you is that by the end of this webinar, if you're in need of a HIPAA compliant healthcare virtual assistant, which is why you're probably on a Snapscale webinar to begin with, because that's what we supply as HIPAA compliant healthcare virtual assistants, I will show you how to get in contact with us and to be able to take that next step if that's what you want to do. But with that said, Gordon, this first kind of question is one I want to ask you about, and that is the problem practices need to be aware of regarding these laws. So, Gordon, the biggest problems that practices need to be aware of regarding these laws.
Well,
and give me some like maybe 3 things that are high risk for medical practices right now.
Well, it's no different than what's high risk already, right? Data breaches, information leaking out, and it's just now becoming a patient-centric focus, right? I mean, I think Zak was correct. It's been very nebulous up to far, and you're going to see the shift of Cures becoming, HIPAA being an extension of Cures Act, and then you have HTL 1 or 2, excuse me, and then you have high tech, and then depending on what industry you're in, the FTC consent requirements are there as well. So there's nothing different that's glaring you in the face currently, but we can cover some of the pieces that are coming up and what does that mean in the future? In the future, maybe tomorrow. This thing is been milled around and tossed around. Many congressional hearings on this, and you got data privacy advocates on one side, and you have Stargate on the other, wanting to grab all the data, right? And the problem is I mean, there was even a recent article yesterday that came out of California. There's a whole movement there for patient privacy and consent in the California rulemaking, and they're worried that Newsom's going to block it. But what does that mean? Basically, it means there's two focuses here. One is protecting data, and the other is getting access to it. And the guys who want access to it, you know, they're pretty much impartial to worrying about whether they're digging through somebody's records or not, right? And that's kind of the you know, the dichotomy there, that you've got two opposing forces. And it doesn't mean that they're not trying to accomplish the same thing. Zach already touched on it. This is all about better outcomes. Data means better outcomes if we can analyze and research and do this. But at the same time, in certain areas, we have to protect the patient's rights, because otherwise we're an open book. I mean, how many times have you been talking in your house about camping, and suddenly you get ads for sleeping bags 5 minutes later, and you're wondering, how the hell did that happen? Right? There's a reason that happens. And Web 3.0 was supposed to be the big convergence where we would get off this, you know, selling platform of the web and getting into the place where we can protect our data. It just hasn't arrived yet. So I just want to go through some of the updates.
Yeah.
I hope that kind of wrangles your question. And like I said, I don't want to be a fear monger that the offices, and I spent many years. I was there in 96 when HIPAA launched. And this is 96 all over again, in my opinion, because it's the deer in the headlights look when this thing drops in their lap, you know. And I feel bad for the physicians, because I called on many for many years in many different, areas of practice. So it's hard enough to be a physician in today's environment. You don't need another layer without somebody telling you why there's another layer. And I think that's where it becomes critical that, A, don't freak out, right? You know, I mean, the bus isn't about to impact the side of your car, but it's coming, and you can see the bus in the mirror. Okay. So you know that something's going to change, and I can kind of discuss, and I've got notes here. So if you see my eyes vert over, it's because I just want to make sure there's certain points I want to make sure we cover.
Yeah, well, let's make sure that we cover a lot of those points and get all of them so that the audience can hear some of the most up-to-date changes that are going to go on. But, Zach, I'd really like to ask this question of you, and then maybe Matt. How is the HIPAA kind of intersecting with the Cures Act and the FCC consent rules? What is actually happening there? Go ahead, Zach.
I can jump in from a real high level, and then Matt can definitely fill in the details. This is really his expertise area. Long story short is, I'll go back to, there's a movement towards patients' rights and patient access and the interoperability of data across the healthcare networks. And all these rules and these new updates that you're seeing for 2025 within HIPAA are kind of reactionary within HIPAA to kind of try and bring the medical community in line with the new regulations that we're seeing around patients' rights. And it's really just a truly operational modification of the HIPAA rules to bring them up to date with the digital age and how information is shared, and incorporate really patient consent. And patient consent, I think you will find, as these rules develop over the next, 6-8 months or the next year or two even, you're going to see that the patient will be at the center of all data sharing. And really, I think the goal is to get this set up so that the patients will have full discretion over who sees their data.
Matt, what does that mean from a compliance standpoint?
Okay, allow me a little liberty here. I'd like to back up a little bit so that this does not all sound like an entry out of 45 CFR. I'm going to talk practically, okay? When Gordon and Zach talk about patient privacy, patient rights, and patient access, those are the foundation of the HIPAA regulations, right? So, I mean, an archaism is that HIPAA was designed for insurance portability and accessibility. That means that back in the 90s, when I left a company and I moved to my next location, let's say I moved from XYZ Steel and I moved to PDQ Steel, sometimes my insurance coverage had a big lapse, and I couldn't get the care I needed. And then it was almost impossible to get access to my records. Now, that's a very simplistic view of what's happening here. HIPAA addressed this. It's codified. As we begin to talk about the things that are coming that are new, Gordon referred to it as 96 all over again and deer in the headlights, to suggest that there are problems that we have to solve that are sort of surprising us. All three of us here in this group can tell you that these rules have all existed. The interesting thing is that though they exist, one-to-one patient consent, I should have pure control over what data goes in and out, including between healthcare providers, as long as it's not patently covered under the TPO rule, right? So a doctor can't share any of my medical information with anybody without my consent, except to collect payment from the guarantor, to provide me treatment, typically within a practice, to appear. Okay, if he wants to send me to a referral to Dr. Johnson and he went to school with him, he still has to get consent from me that he can share it outside of the practice, and that my data, for purposes of data aggregation and operation, collecting statistics within the organization, those things are covered. So they don't need my consent, but literally everything else must have my consent. The interesting thing is there's not really a functional technology, or there hasn't been a functional technology in place to make that happen. Here's the facts. There are X number of provider-specific and industry-specific EHRs and EMRs. These things are high-tech repositories, data aggregators, and vaults for my PHI, and I'm unequivocally protected. Technology maximum. When a referral is sent because I have a bunion, and it gets sent to my podiatrist, there is not currently a technology in place, and I laugh because this is 2025, people. We don't have a way to restrict the data that guy receives. My new ostensible provider, Big Toe Podiatry, gets most of or all of my record in every data request. 45 CFR 164.502 or 503 specifically describes the minimum necessary rule. It is a foundational, it's a mantra in HIPAA, and that you would violate the minimum necessary rule to share my data with somebody is, to address a little bit of drama, it's unforgivable. It's a basic fundamental sin that should always, from a HIPAA compliance standard, should always be underscored. So, little background, HIPAAtraining.com is under the corporate umbrella of digital compliance. HIPAAtraining.com has been working for 20 plus years. We have an interesting business model. We're a facilitator, so that is, we can be reached by the phone almost all day long. We always return phone calls, and we always have painfully long, drawn-out conversations so that everybody understands what's going on. And that may not be the corporate model across the industry, but it's so important, because merely filling out pieces of paper that say these are our policies and procedures are no guarantee, outside of combined due diligence and careful use of language. It's no guarantee that you're going to be protected during an audit. When these gentlemen talk about interoperability, right, they're talking about one system, I'm going to throw up some air quotes here, one system's ability to communicate quickly, effectively, efficiently, and compliantly. That's the rule, whether or not they're affiliated one with another. And it's this governmental standard, right? And it can be read. We don't want to pretend like this is a brand new rule. It sounds new, and it could be that maybe nobody listening to this webinar has heard of the 21st Century Cures Act, but it is years and years old. The difficulty has been enforcement, because how is the government How is a governing body like HHS with the OCR, right? How are they going to enforce a rule that is physically impossible, is the argument, to follow? Well, in the compliance world, we know that you can't enforce something that someone can't follow. What we're talking about is the practicability of being able to be compliant. If I were given time to go through, I guess we will. We're going to go through some common violations, some big picture violations. In none of those are you going to see them trying to enforce punitively a failure to follow this minimum necessary rule. But arguably, the minimum necessary rule is far more important than any of the individual other violations. Gordon spoke of the bus in the rearview mirror. What the industry needs to know is technology is catching up. And one day, and you know, I'm not an insider, right? I don't understand the pulse of the industry in the data sharing and the data collection industry. What I do know, in the last 2 years, it has gone from zero conversation about the 21st Century Cures Act. Never once in the previous 5 years or 6 years have I had a conversation with a client about this 21st Century Cures Act. Now it's all over the place, and clients are starting to ask, you know, very awkward questions that I have to say, yeah, technically we are responsible for, and we always advise you to follow this minimum necessary rule, but there's not much enforcement unless it's a blatant refusal to follow the due diligence of this. You can always blame it on your EHR or your EMR, but I'm telling you, fact, enforcement is coming, and it's coming hard and fast. And once OCR gets their hands on a technology, it's going to be 100%. And the impact it's going to have, especially on Medicare payment recipients, I don't have an apocalyptic word for it that would be appropriate, but it's to say the least, it's exciting, and not potentially in a good way. So
guys,
I hope that was helpful. But
it's extremely helpful, Matt, and I totally sincerely appreciate the explanation on how they all intersect and what practices need to be paying attention to. Because you know what this reminds me of, guys. Like, I'm going to keep this in the layman's terms because, like, I'm not an expert at HIPAA compliance either. But when I'm hearing you guys talk, the other day I went to get the emissions test done on my car in the safety inspection. And I found out that there's certain organizations that used to do this just naturally. They used to do the safety and emissions inspection. Nobody does it anymore. So you're calling all over town trying to find a mechanic to be able to do the safeties and emissions inspection that the government's regulating, that has to be done so that I can get my tags for my car so I can continue to operate a vehicle and go earn revenue. And nobody will do the stupid emissions inspection. Am I hearing that there's essentially an emissions inspection that nobody's doing right now in the EMR systems or any of this that may be an issue for healthcare practices? Yeah, go ahead.
I'm going to use your metaphor. Yeah. Let me interrupt for a second. I'm going to use your metaphor. This situation is as if the emissions requirements have been around for 20 years, 10 years, but there was no way to get an effective reading at the level that's required for state operation of a motor vehicle. But next Thursday at 3 p.m., they say starting on April 1st, we will begin enforcement. And then literally everybody in your municipality and the surrounding area is going to be looking for the same guy you're looking for. How on earth are they going to be compliant in that short period of time?
Jordan, go ahead. Let's talk about those changes. Yeah, what are they? What's going on? When is this happening?
You know, we're kind of got cart in front of horse here a little bit in the order of, you know, we haven't addressed actually what the changes are, but let's talk on a few things. And this is why we can point to the fact that next Thursday, when the emissions testing is required, in the background, what Matt probably doesn't realize, very few people realize this, but HHS is now aligned with ONC. They're not two separate organizations.
What is HHS and ONC? Just help clarify that.
Okay. So HHS, right? That's the Health and Human Services folks, right? This is everything child welfare all the way to administering, grants for organizations to improve care, right? And then you've got ONC. That's the Office of National Commission for IT Health. That's who actually created or was in charge of the Cures Act as far as is what are the punitives going to be? That was ONC. And they basically came up with a ding. In 2024, they made their first round of, okay, we're going to go after some folks. And they went after some high-level health organizations. And there were some fines, and I know Zach knows intimately those scenarios a little better than I do, and we'll discuss that. But now you have this alignment, because ONC, what they wanted to do was focus with CMS on Medicare, right? That was the easiest one to hit, because we know we're doing Medicare audits, so we can go there first. And for those of you on the call that are familiar with MEPS, so if you get dinged in an audit for violations and non-standardization with cures, they were going to impose a 25% cut in your MEPS, which would bring your Medicare payment reimbursables. So basically all the profit that you were going to make on a Medicare patient is now out the window. Okay. And that was the rule that came down. But HHS was enjoying having access to all this data. And so there was a kind of a governmental argument, if you will. But now these two organizations, as recently this is what they've been doing. They've been reorging at the government level so that they can get in the bus and come up behind you or get the emissions testing going, however you want to look at that, right? So it's imperative that this is coming. And I'll discuss the security implications. We're talking HIPAA in the past. HIPAA was paper, right? Cures is electronic. The FHIR standard is what Matt was referring to. That is the government in the healthcare sector. That is the government compliance interoperability standard, right? And to share an example, because you brought up minimum to treat, I'm writing notes down here. Minimum necessary to treat, when you look in the CFRs, that's been around for a long time. But the EMRs never took notice of that. So they request something you're going to send out to the radiologist or, wherever it is, it's all or nothing, right? Unless you're sending paper records, it's, by fax, it's all or nothing when it comes out of that digital EMR. And so InterCorp, when Cures launched, we as founders said, okay, we're going to build a software platform that is FHIR interoperability. And it was based on patient consent. It's a platform where either provider or patient can use a portal to filter out what data they will allow to be sent, right? And as an example of where this is backfiring, Oracle and Cerna, at the VA level, you've got lawsuits coming in by the boatful because you've got wrongful death stuff coming down because they failed to treat. And it's a mess. A military record, I know Matt will know this because we were both military members. Our medical records in the military, it's not uncommon to see 150, 250, 400 pages. And what was happening, I can tell you locally here in town at the VA, just arguably the whole system went down for like a week. Right. And so no data was flowing in or out. And that was just last week. So the problem is the referring offices locally, because that's how the VA operates mainly, is, the cardiology and all the specialties are getting going downtown for that work. And they started refusing VA patients because of the data flow, because they weren't getting I need one page out of that 150. Right. And they're receiving 150. Now that physician is responsible for every piece of data that gets delivered to him. And if he misses something, then we get into the whole, treatment liability piece. So there's a whole confusion as to how to shore this up. And what we built was it's built, it works. It just hasn't.
Hold on one second. Hold on one second. I don't mean to cut you off, Gordon, but you said something that's so imperative that I want every single provider that's on this show to understand and be aware of, is that they stop refusing treatments to the VA patient as 150 pieces of data were sent to them that they just became responsible for because that data was sent over to them.
Right.
When you receive data as a physician, you now become responsible for every piece of data that's sent over to you. And so I want you guys to I want you to talk a little bit about your system, Gordon and Zach, but I want to make sure that everybody on this call understands every single piece of information that comes into your practice when it revolves around healthcare records becomes now your responsibility. Go ahead, Gordon.
Okay. Yeah. And it's, I think that most physicians understand that, or if not, they're at least the people that are on this call today just were made aware of it. And it is why these groups, physician groups or independent physicians stopped using. And so, of course, you had all these VA patients that weren't able to seek treatment. And so you've had some patients that expired during this interim period. And of course, now there's lawsuits against the VA. And I mean, we're not just talking a handful. So it is a nightmare trying to worry about how data is moved. Okay. So, and now you've got new rules that are even making it, more difficult, because cybersecurity and data is one of the big points of this, of Cures 2, which some people are calling it, right? It is, they're just piling on into Cures more and more pieces, which are going to flow down to HIPAA. And I think that's what Zach was basically, describing. Everything's funneling down to HIPAA, and suddenly you're going to be responsible for it on next Thursday when the emissions test is due. So so some of these overhaul pieces is just stricter handling of electronic PHI. That's data at rest and data in motion. And data in motion is what we're describing, that patients and providers need to consent when that data leaves. And we have the virtual trust, which is the VT at the end of InterCorp. The platform is a granular filter. So both provider and or patient can basically parse through. I don't want my reproductive health going to the podiatrist for the bunion. I don't want this data going there. And so it can be filtered. The provider can do the same thing. And now he's mandated with the CFRs, right? If there's a data breach at the podiatrist office, the physician who sent the data is going to be hung out. And so those patients can come back on them. And Zach will probably describe a few scenarios where stuff like this just happened, right? I know Matt last time in his last HIPAA discussion talked about a hard drive that got pushed into a computer that went to a church's yard sale thing. And somehow that became a $3 or $4 million, and I'm laughing because it's just incredible that you don't think of these things. So
yeah, you can buy an insurance policy for cyber attacks for the cost of that, but how do you buy a cyber policy against HIPAA violations?
Usually, you're talking about, it's my opinion that in the future when we see these, because you got people company I worked for when we had our laboratory, it was held for ransomware, right? They invaded the system that we were leasing space on a system. It wasn't even our system, but they got held. The FBI got involved, and we lost 9 months worth of data, during that process of them trying to rebuild, because they did shut the system down. And I mean, it's scary when people can do that. And that's why this whole security piece is, I've got 5 or 6 things up here on my screen, my other screen, and it's all about IT asset management. They're going to increase the risk assessments that you're going to be at the office level. You're going to be responsible for it when you go to an audit, right? They're going to enforce encryption, MFA. That's that annoying thing when your cell phone rings and you got to get the code. The multi-factor authentication. As big of an annoyance as that might seem, it's just another level of security, right? Then you're going to be required in the office to have your multi-factor, your network segmentation, malware. You're going to need all your portable devices to be secure, whether it's the printer or whether it's this or whether it's that. Anything tied to your Wi-Fi network is an entry point, right? So all this stuff is falling down in regulation now because there's been so many breaches. And there's an entire list here that I won't even go through it today. I mean, I wanted to let everybody know that we're planning on a series of these calls, and we have experts from ONC, we have experts from the VA that can kind of fill in a lot of these blanks as to what's coming. But cybersecurity of PHI is extreme importance, and it's gonna fall down again to the physician level to be responsible and understand what they're responsible for. The audit frequency is going to increase. There's no doubt about that. Now that you have this alignment of ONH and HHS, they're just gonna crank it up, because all it takes is for them, when the government has one of these breaches or something, who's pointing the finger? So it's always going to fall back to the physician provider level. So that's something you always have to be aware of. So there's a big challenges, right? And we address that as a company in several ways. And we've developed 3 products. The virtual trust platform that I described with the filtering has not been launched yet. It's not been deployed. It's been completed. We are in negotiations with some folks at insurance companies, because when we talk about this thing, Matt brought up payers. Moving data to the payers is allowable, but that data now has to be secure in motion, right? You can't just go and use you can't get on Square or whatever your payer system is. And that creates, believe it or not, a link back to PHI when you start doing those things. If I'm an abortion clinic and I charge somebody's credit card, suddenly there's an implied medical record there, right? So there's all these little areas that are in nuances that are gonna change up. And so I think it's important to kind of understand from a broad perspective what's going on there. And so that part we are addressing, but currently we also have a digital consent platform, which we can deploy currently at a provider's office, basically to electronically and digitally hold all their consent, get rid of their paper, make their lives easier. It's very simple. We have a HIPAA secure server system that holds those consent records. So any audit comes up, we've got it. It's not like a piece of paper I'm going through the desk drawer to try to find. So that is one aspect that helps with the audit. Basically, what do I do with this audit if I get found out here or here or here? And then we have a kind of a new scanning tool. I know Zak can touch on that probably a little better than I can, but it basically converts printed data on a piece of paper into a digital record, so that you're not having to you get transcription errors and whatnot, pushing data into your EMR system. And as a front to that, we have several EMR companies that are speaking with us currently about wanting to look at virtual trust layered on their platform, because otherwise they got to go back and re-engineer everything. If they go this way, it would be basically a standoff system, but it filters through the EMR when data wants to travel. So those are kind of some of the things that we've done. And, I don't want to make this a commercial, because this is supposed to be more educational. So I want to keep it on that level of what's coming. And I think, Zak, do you have some input on those pieces?
Well, I have one quick question. Just I want to make sure that we cover this in the time. Is like talking about like how the clinics and the doctors can pragmatically work on this now. Like, what are some of the things that they can do to kind of get at this now? And really, like what we said in the beginning, like if you just work it a little bit, it's not an awesome ordeal to manage, right? So what's some practical steps that the doctors and the clinics can do to kind of get ahead of this would be awesome?
Well, I think I think managing the consent is the first piece, right? Because that underlying, that's everything in Cures, is interoperability on one hand and consent on the other. And I can tell you, like I said earlier, we've got this dichotomy, there's 2 divisions where I want to protect, but I need the data to make better outcomes. And there's got to be a marriage somewhere in the middle that makes that work. So I think as far as the office is concerned, keep doing what you're doing. You know, shore up your consent patterns. You can obviously talk to us about digitizing that consent, and it just makes your life easier. You got less keystrokes and less things to do, less paper. And I think that that's the first thing that I would focus on. And then I would, you know, you're going to have to start turning inward to cybersecurity within your system. I mean, you know, what is my network compliance? Who is my IT guy? Needs to be working with my compliance guy. And I think this is an area that, given the name, that we can work with digital compliance on, because basically this is going to be the next extension of procedures that they're going to need to, because people are going to start calling and asking. It's just how it is. This information is floating out there. You've got all these experts that consult to the ONC and work on these things, and they're scratching their head as how there's no phasic plan for this to roll in. And suddenly it's just going to roll in on top of you, and you're going to be going, great, now what? So we're hoping
your technology just
will address a portion of those things. And our technology is based on data and movement, you know, and not in the minimum to treat piece, right? I mean, that's really what we're focused on. But that doesn't just apply to healthcare. They're making, what we might think of as healthcare. This goes down to anything that creates PHI, like Zak was saying. The FTC and FCC are all over the Fitbits and the Stravas and the Garmins. And I got blood pressure. I got a name. I got a person, phone number. I've got their blood pressure. I've got their heart rate. I got where they are. There's a lot. I mean, this breaks down into the RPM world, you know, whether you're heart monitoring or whatever you happen to be doing. And that data is A, not secure, right? And B, it's not supposed to happen without patient consent, right? I mean, every time a data movement happens, it's supposed to be consent challenged. You may have signed something when you agreed to the user agreement that, you know, that was 26 pages long and you didn't read it and you just hit accept. There might be a consent form in there, but it requires every time data moves. So the FTC and FCC are requiring one-to-one consent. It was Zak. They rebounded again because the technology was not enforceable enough, and they pushed it back out. We're pushed back out another year.
Yeah, and that was part of the issue. We see the federal regulations coming down with more stringent regulations than the technology can keep up with currently. And really, I think the big goal that we're looking at is not only to get offices in compliance with the regulations that are today, but provide compliance solutions that are actually compliant for, you know, future-proofing your business, if you want to use the really fancy, trendy terms. But that's what we really focus on, is providing something that adds convenience now, but is in compliance with the future regulations.
Yeah, and it's so important that we're HIPAA compliant. I know that I have talked with you guys offline, and I have heard a number of different stories of people who aren't compliant with the HIPAA regulations and fines. Matt, what are some of just for entry-level fines, what are some fines that people can have received previously for the first time violation that data has been breached?
I'll answer that for you. I've got a couple favorites. I'd like to preface this with, I'd like to amplify what Gordon said, that we don't want to fear monger this, okay? But as we speak of it as if it's preventable and avoidable, as if it's not as common as a statistics page on hhs.gov might make it, that doesn't mean it doesn't happen, and it doesn't mean that enforcement is not going to increase as these technologies become available, and we can no longer say, well, my EHR won't do that. That won't be an excuse in the future. To answer your question, though it's not common, you can go anytime you want. You can do a web search for like recent violations or citations or punitive action, HHS, HIPAA violations, right? And you get, not speaking, I think we're going to see the largest fine in history coming sometime this year, because you had to have heard of it. And if you haven't, I'll be happy to share it with you. Last year, February, so just over a year now, a subsidiary of United Health Group, Change Healthcare. They are a massive holder of health. Almost every record in America is in this system. It's sort of an interesting side note to wonder, do they have consent for all that information? But that wasn't the point of the audit. The audit found a breach. They got ransomed 190 plus million records, not pieces of PHI, but whole records. So we're talking maybe 1 billion pieces of PHI or more. They got ransomed, and the only reason it happened is because among their hundreds or their 1,000 servers on which this PHI is stored, one of them was a legacy drive or a legacy server, and it had not yet, or it got overlooked during the implementation of two-factor or multi-factor authentication. And here's the interesting thing about this citation. The citation is not you lost 190 million records or 1 billion pieces of PHI. That's not the citation. The expectation is, even though this is gargantuan and ridiculous, the expectation is that if you are making due diligent efforts to protect your PHI, you're going to have a breach anyway, because hackers tend to stay ahead of the technology curve because they are the ones that drive change, interestingly enough. So the citation was merely for having one unaudited server. One unaudited server allowed them to move laterally through the entire system and capture not all of their data, but enough of it to be ridiculous. Okay, this fine will be, you shouldn't read it without having a glass of whiskey with you. Whenever it drops, it's going to be ridiculous. Okay, and I say that with this context. Here's a context for you. Here's some fun ones. Let me pick one. Okay, so
but Matt, I'm Joe the doctor. I'm
Right.
Joe the podiatrist. I'm Joe the foot and ankle guy, right? I have 300 to 5,000 patients in my database. What type of fines are you aware of that have applied directly to me? Because that seems so incalculable in my mind that would go on. But I'm Joe the doctor. Help me understand what this might cost me.
Okay, here's an example. You can look this one up. So Lorien Health Services, Lorien, in 2024, and these guys have a network of nursing homes. So they may have 2,000, they may have 1,500 to 2,000 continuous health residents, okay? Maybe 100 to 200 permanent employees and whatever rotating staff. So we'll call that a middle-sized business. They faced what was their citation was, among other things, having unlicensed individuals, untrained part-time individuals step in and perform a very simplistic, what would be the equivalent of home health care services for residents. The folks weren't HIPAA certified, simple as that. So imagine somebody who does not normally participate in your practice, somebody's covering a shift, right? And they're not qualified for healthcare, but they can do bed services and toileting and hygiene and stuff like that. Because they were able to access, by virtue of just being in the room, health records and health information, medication regimen and things like that, the facilities were fined like $50,000 or $60,000 with no breaches outside of the employed staff. So if you have an employee, the reason you don't have a business associate agreement with your employee is because they're your agent. It is assumed they follow your policies and procedures. Well, Lorien Health Services has policies and procedures like any good business who's HIPAA compliant would, that says we train our staff XYZ. These are the folks that have access to patient care. These are the ones that don't. We will only train the staff. Oh my gosh, and this happens so often. Does my whole organization need to be trained? We have 150 employees. No, technically they don't. However, if they come in contact with PHI, or it is reasonably expected that they could come in contact with PHI as a normal part of their operating business, then you should, right? They didn't get dinged because they weren't certified. They got dinged because they weren't certified and had exposure to PHI, and they were asked to as a part of business. It wasn't incidental exposure. It was what they were asked to do to cover a week shift or whatever. And Now it's $60,000. And that's just the citation for that. We don't know what other citations that came along with that, but it was hundreds of thousands of dollars total.
That's crazy. I'm going to ask this question of all three of you so that we can move towards wrapping up, because we're coming up in an hour, believe it or not. But Matt, you talked about protecting PHI, everybody in the organization being HIPAA certified in the BAA. What are some practical steps that when they're working with vendors or outsourced relationships, should a practice be looking at? And I'll ask the same questions of Zach and Gordon about the same way. So what are some practical steps that if you're outsourcing, you have a vendor relationship, what are some things that you should be looking at from a vendor perspective according to these laws?
Okay, I'm only going to address the BAA portion of the question. Any technical or data questions, electronic data, I'll leave to the InterCorp team. So the fundamental, and I'm going to say the most easily ignored, and it is a commonly cited issue. I find a service that is going to dramatically either help my patient outcomes or it's going to help me reduce my administrative load. So I sign up for this service. I'm not sure if they're the one I want, so I'm going to try them for a month, right? The first thing we should do is our most significant vendor due diligence step, which is a BAA, and then the due diligence, sort of generally, ethereally speaking, the due diligence that surrounds a BAA. And here's what that looks like. The first rule of BAAs, and we have this all the time, is if at all possible, it should come from upstream. So if you're a BAA, if you're a business associate, and you're working for or on behalf of a covered entity, the covered entity with whom you're contracting to provide a service or a good should offer you their business associate agreement. It is not a must rule, it's a should rule, because they carry all of the liability. They carry most of the liability when it comes to a breach. No exceptions. It's just the way it is, okay? I, as a healthcare provider, or I, as a health professional that aggregates data, I am considered the primary intake of health data, so I'm a covered entity. I'm responsible. If, in many cases, this is what happens, they fail consistently, you're already contracting with them, you're already touching data, and they have not yet, Sharon's on leave, so I'm sorry, we'll get you that business associate agreement as soon as she gets back. That's a no-go, 100%. Don't do it. I know that operation costs are high and you need the income, but fines can get up to $3 and $5 million. That's a large fine, just because business associate agreements were not in place. So even if you have to offer them, and I recommend if somebody's lollygagging and not getting you a copy of a business associate agreement, you send them yours. And you make a statement that says, we are already providing services for you. Please sign and return this BAA. We can revisit it when your administrator gets back in, but both of us need a protecting contract to make this legal, okay? BAAs are negotiations. They're contracts. They're a set of offers and a set of counter offers. It is totally fine to negotiate clauses, but the minimum basic is identifying who the covered entity is, identifying who the business associate is, and then there's on ours, it's a very old school BA agreement. There's a blank line that says authorized use, and in this line, you must put specifically what information you will have access to by contract and how you are authorized to use it. Anything that's not on that line should never be questioned. You should never say, this seems like it's like that, we should be able to do that. Don't do it. Just modify the BAA. They take it so seriously, it's a legal contract and it's binding.
So to jump on that, Matt, with you, it's just, right, as part of this whole thing, what is that bottom line? And that is going to be, because we're in a world now, I mean, Snapscale is right at the forefront of this, right? We've got telehealth, we've got virtual assistants, we've got outsourcing. We're working with a new company that's starting up, their own service for emergency care online. These things all require that basic premise that you're going down. And then it also requires a consent platform to be in place to make sure that we have consent to talk about these or talk about this or talk about that. It's not cut and dry with the BAA anymore. I mean, there is an extension of it, if you will, because healthcare, it covers dentistry, it can cover, a whole naturopathy. I mean, it can cover chiropractic. It's anything where there's a healthcare record. It's an expanding field. And I just want to get this last point in before, I know, Nathan, you gotta pull this to a close, but the problem and there's recent surveys going down from patients are withholding data on purpose because they don't trust. There's a level of trust that has to occur between physician and patient. They're withholding data because they don't trust where it's going to be used or used against them, right? And so you talked about these millions of records at United Health. The question I have is, currently, how much of that data is even current? Because people are starting to pull back because they know that the privacy rules are not being followed. So that's something to be aware of as an office. You need to keep that in mind, that, privacy at the forefront. You got to build that trust.
That's right.
100%.
That's right. I'd like to throw this there. And it's because some of that data is sensitive. Sensitive doesn't mean it's embarrassing. Sensitive means it could have implications on the practical life of the patient. So all moral and behavioral arguments aside, if I have a condition that I'm getting treated and I'm withholding information because of Gordon's trust issue there that has been around for generations, if I withhold information because I don't think it's relevant to what I'm being treated for, and it turns out that my minor early onset cardiac issue is secondary to my use of marijuana or meth or something else, no way am I going to give up that information because it's incriminating. And we know that HIPAA gives protections to everybody except in the event of law enforcement request. Now, HIPAA is very strict on how law enforcement can get that information. However, people who are under the stress of a badge and a person in uniform don't necessarily follow those rules when they give up that information. They're not willing to get arrested on the short term to deny access without a warrant. And if we live in a world where this information there are just things I'm not going to tell you because it's going to cook me in the end, right? This is not citizenry, curatives. We're not trying to make people better persons in the clinic. We're trying to make them healthier persons. And when we have, for an analog, if we don't have any faith in a client-lawyer relationship, if that can be just brought out in court and broadcast everywhere every time somebody gets the right piece of paper, no one's going to be honest with their attorney and they can't be defended in court. And the same,
quite frankly, it sounds like these laws guys are trying to protect us from Big Brother versus hurt us. So I appreciate your wisdom and thoughts on this. We're right at an hour right now. Zach, I want to make sure that I give you an opportunity here to tell us a little bit about your organization, and then we'll wrap up with Snapscale, and we'll wrap up the webinar for everybody. So tell us a little bit about your organization.
Oh, thank you very much. Yeah, InterCorp is a patient-centric organization, and we developed a platform called Virtual Trust that Gordon kind of talked a little bit about earlier. But really, we build trust between patients, providers, payers, anybody in the healthcare industry. And our program and our entire existence really is to facilitate the patient's control of their healthcare records. And once you bring the patient into the forefront of your practice, our theory is, and our basic approach to this, we think we're right, is once you start engaging from the patient level and inform them, they can help you move medical records. They can speed up the process. They can actually request from other physicians that you get the information you need. And when you start getting that global perspective on the patient, whether they were treated in Maine, New York, LA for that matter, you can pull the entire patient record together and be able to improve the outcome for that specific patient. The idea that we do this specifically by using and leveraging patient consent is kind of novel in the industry, and putting that burden of giving consent to access on the patient, which really frees up the provider to have access. And then again, moving records comes to the standpoint here where we want to make the providers empower the providers, I guess you could say, to provide good service without imposing more restrictions on how you do your job. Really what we're trying to do is alleviate the paperwork crunch and let doctors go back to being doctors. And so that's what we focus on. And we roll out all kinds of different applications tailored to different organizations, really focusing on the patient. And it's a really flexible system that we really believe in. And we think it really benefits not only the patient, but also gives a lot more latitude to providers. So certainly it's a benefit to the industry.
And also,
Yeah,
one thing is it works for every clinic too. It's not cost prohibitive, is what I'm saying. So it really allows all clinics of all sizes and doctors and practices to get this compliance, right? You don't have to be a juggernaut to be compliant, right? Or to comply with this. So that's one of the things I wanted to bring up too. All of these things we're talking about, anybody can do it, right? It's not like something that's insurmountable. It takes some organization, like what Gordon was saying, and a little bit of technology. And it's here. So there's no reason why everybody shouldn't adapt to this sort of stuff. It takes a little bit of time.
And that's really where,
but every clinic should do it.
And that's where Matt comes in with digital compliance and their compliance consultants, especially because compliance is not the same for anyone. Every office is unique, and every office, I mean, a shameless plug for Matt, every office definitely needs someone to be their HIPAA compliance consultant, even just to hold your hand just in case. It never hurts.
Yeah. Yeah, I totally appreciate that. Matt, as we're getting questions in, I've got two different platforms. We have the online platform, which it doesn't look like a lot of the questions are coming in from the online platform, but I got a separate platform of questions that are being submitted to me throughout the show from a different online marketing tool that we're utilizing. And why don't you tell everybody a little bit about digital compliance, and then I'll ask you guys these questions that were asked from the audience, and then we'll wrap up for the day.
Sure. Digital compliance, digitalcompliance.com is where you'll find a buffet of websites that cover various compliance topics. I am primarily a consultant for HIPAAtraining.com, though I've got some minor expertise in other subject matter. HIPAAtraining.com is not a high-dollar consulting firm. HIPAAtraining.com is built to reach as many people as possible, and as we are physically able to provide one-on-one consultative help to bring people into compliance. The catchphrase at HIPAAtraining.com is fast, easy, and simple. That's relative to the size of your organization, but one thing I can promise you is top tier, best in the industry customer service, in that humans pick up the phone and walk through whatever your issues are, and there's no limit on how long you can have a phone call. Okay, there's no charge for consultation as long as you own a product with HIPAAtraining.com. We, within reason, will consult with you as often as you need. We'll help you answer your questions. We will literally help you put together your policies and procedures. We will not write them for you. We provide policy and procedure templates. All of our products are a fixed cost. There's no hourly fees, no membership fees, and it doesn't cost anything for you to take a question that you didn't think of today during the webinar to call in and ask. I don't know if you're putting the information anywhere, so if anybody in TV land wants to make that call, I'm making this preamble so that you can get a pencil ready and write this down. It is a Austin, Texas phone number. It's 512-402-5963, and you can call in to any of us. All of us are full-time consultants. We're not salesmen who wear the name consultant. We do not make any benefits from selling products. We are paid as a wage-earning professional is paid, and our primary job is not to generate sales, but to make sure that you're compliant. Sales happen organically through people having needs. So just take your question. I'm at extension 106 if you want me personally, but if it rings through and I don't pick up, General will pick up, and we'll be happy to help you with any HIPAA question. If you have questions specifically around the Cures Act and the impending deluge of regulations that are going to come and modify the world, especially for Medicare recipients, providers that receive Medicare payments, I will take that call. and then I will gather all the information you need, and I will get you a consultative call with InterCorp. They've got a team that will help you with this. Mike is an interesting example. Mr. Yablonowitz and Snapscale, previously Brobisco or BBC Global. We don't know, HIPAA training doesn't do webinars. We don't partner with clients and help them market. My purpose of being here is not for marketing. I'm not interested in generating sales from web contacts. What I am interested in is taking information that shows up regularly and becomes problematic regularly for our clients, so that you're conversant and know how to ask questions and know what the answer should sound like. Mike is an obsessive when it comes to compliance. The way he approached compliance when he became our customer 3 years ago was, but how do we do better? But I know what the minimums are, but I've got some clients that are concerned about VAs, and what do we do to bolster, Matt, honestly, how do we show up as the best in the market? And it was a year, maybe a year and a half working together on a system that didn't exist. It doesn't exist anywhere. I can tell you, we have dozens of virtual assistant platforms that work through HIPAAtraining.com, and there are probably 100 more that work through other of our peers in the industry. And the reason Snapscale is the only organization that we will do this with is because they exceeded the minimum standards. Then they exceeded what were considered exceptional standards. And then they started creating their own standards that are so far and above, they're so beyond the pale that it's going to generate a new standard in what is considered remote virtual healthcare. Okay, there's a whole conversation to be had about that. We don't have time for that because we're already over. But again, anybody here would be happy to speak with you personally if you have a question, just for the sake of educating you.
Let's go ahead and take some of those questions. I got 3 of them here that are good ones. The first one is, I use a paper intake form, and this is a hearing clinic, actually, believe it or not. They use a paper intake form, and they're asking what areas should they convert this to digital in order to be able to be compliant HIPAA? They're very concerned, it seems, that they take their patients' data over forms and put it in a physical file right now.
I'm going to answer this really quickly in one sentence, and then I'm going to let Zach grab the rest of this because it's in his wheelhouse. The general answer is, technically speaking, paper is compliant. Nobody questions that. HIPAA always prefers digital data because ostensibly it's easier to secure, and you can secure it more comprehensively through more layers. So if I was your consultant, I would say, yes, digitize it. Okay. If you don't, and you want to maintain the paper intake forms, then there are a series of physical steps you have to take to secure that stuff. With regard to the digital information, I'm going to pass that to Zach.
Yeah, that's a great response. The other addition I would add to that is, if you have any of the records in digital format, subsequent to that, if you record anything digitally, I would definitely do the intake in a digital format. And at the front end, then you'd be able to capture the patient consent profile as well as the intake form. So you kind of kill 2 birds with one stone right at the beginning. And that absolutely would get you ahead of any of the HIPAA requirements. And like Matt was saying, they do prefer digital. So if you do digital records, I would definitely recommend transitioning to a digital intake form and protect it with patient consent.
Yeah, 100%. All right. Second question that's came in here is, all right, so let me see if I understand this correctly. All right. So they have a call center. They have, it looks like 6 people in a call center, and they're asking, some of the people do certain tasks and other of the people are responsible for other tasks, right? So these call center representatives do a certain number of things, and these call center representatives do a certain number of things. They both have a HIPAA certification, but is there certain, with intercompany, can you share all patient data, or can you only share parts of patient data that are necessary to the job? I guess that's the best way I can ask it.
That's an excellent question. This is something we dealt with early on with the virtual assistants for Snapscale. Okay. This is really complex, honestly, because as a consultant, I would ask you 5 or 6 or 10 questions. I'm just going to assume I know the answer to all these questions and make this short. No, it's not okay. Generally speaking, don't do it. Let me give you an example. Nate and I are 2 virtual assistants working for 2 different clinics. We're partners in a very small startup. We do our own work, and we're going to scale as soon as we get enough clients that we can handle. I cover healthcare clinic A, and he covers healthcare clinic B. We put an LLC over us because we're making enough money now, and now Gordon is our head of operations. He doesn't have access to PHI, and it's in our policies that he should not. He's HIPAA trained anyway, just because it looks good on paper. Nathan is collecting data from one healthcare provider. I am collecting data in a way from another healthcare provider, and there should be no marriage of the two. He is under their policies, which has their minimum necessary access rules. I am under my healthcare clinic as an agent working for them. I'm under this healthcare, was I A or B? I'm under healthcare clinic A's policies, and he's under healthcare clinic B's policies, and the assumption is they're different. Now, even though we're one organization, the agents work for the clinics during the hours that they are on call, and there should be no sharing, and there are exceptions to this rule, and it might be popping up in your head right now, but what about this? But because there's this nuance, well, I can't have the nuances right now, so as a general rule, don't do it. When in doubt, just don't. If you have a question about that specifically about your operation, feel free to call.
I'm going to ask a question just because it's going to clarify this also. So I have I'm a physical therapist. I have multiple clinics. Okay. I have a clinic on Tom Street and a clinic on Bill Street. The patient leaves Bill Street and goes to Tom Street, right? Can the clinic share the data between Bill Street and Tom Street?
Yeah, no, they can't. Because imagine if there's no difference because Gordon or Zach runs the organization. And from the patient's perspective, the assumed consent model is for my care provider at a location. So there's this rule I mentioned earlier called that authorizes the sharing of the data in the cases of treatment, payment, or operation. In the case of treatment at Bill Street, there's actually a specialist over at the other one that's probably ideal for this. But for the sake of propriety at the very minimum, and for you risking an HHS auditor trying to determine whether or not you're technically the same clinic, like they're going to get into your life in ways you had no idea people could scrutinize you because they're very interested in the rules. So you need to assume, oh my gosh, there's so many interesting asides to this. So again, please call with any questions. But you need to assume the people that can share that you can share the information with, and just always apply the minimum necessary rule. It's somebody in the practice right here with me, okay? And they actually have expertise in an area that can improve the outcome for this patient. I cannot, and I may not, and I should not share information with just anybody I want in my own organization because the patient did not contract with that care provider. So you are making a discretionary judgment that you think that this is going to be okay for treatment and it was beneficial for the outcome of the patient. And I'm telling you from experience, that does not always work. You can have a person in the same building that has no right to see that information. And if that becomes a breach, well, God help us all.
Yeah, absolutely. That's why we do this show. We want to make sure that you guys get the opportunity that are watching online right now, watching on replay, and that are participating with us as a community, learning all about these healthcare laws and rules. There's more questions that have come in. If any of these questions haven't been answered in the show already, then I will send them over to Matt and Zach and Gordon. One final question, though, that did come in, Zach and Gordon. If people want to get access to this affordable digital compliance tool that they can put in place for digitizing the onboarding of their records and patient private health information, check boxes and audits and the whole 9 yards that you guys do, how do they find you? How do they get in contact with you so that they can walk through that with you?
Yeah, I think the best way to have the participants today to reach out to Matt, and Matt can kind of walk them through a really customized approach to how they can do this. We always start with patient consent, and Matt knows that. And then from there, we can build a customized product to specifically meet their needs. And when I say customize, Our entire system is a toggle on and off. So it's kind of order off a menu. If you want one thing, as long as you have patient consent, that's the only requisite. Outside of that, you can stack whatever services you need. So just reach out to Matt and he'll be happy to kind of do an assessment and then get you in touch with us.
Awesome. Well, thank you very much, guys. So thank you very much, guys, for participating in our webinar today. I appreciate it. And from the bottom of our hearts, thank you very much for being a part of our program today.
You're welcome.
All right. I'm going to take them down Mike and I will finish up here, the show here. So let me do that. Mike, that's HIPAA compliance, huh? These guys know exactly what they're talking about. That's an incredible amount of information that the audience just got. We got a couple of things I want to walk through with everybody. I'm not going to go through all of this that I had planned for you guys, but we have a number of different case studies that we'll be able to provide for you. Here's just an overview of some of the different case studies that we could provide for you of clinics who have worked with Snapscale. If you guys are interested in partnering with Snapscale for HIPAA compliant healthcare virtual assistants, you heard how our organization is the leader in this area, not from us, but from Digital Compliance, which helped us structure and put together our programs to be the leader. Go ahead and scan that QR code. Go to snapscale.com/start, and you can set up an appointment to speak with an outsourcing expert. Mike, that was a lot of information.
It was, but it's important. Like, one of the things that we try to do when we partner with these, healthcare clinics and practices and practice owners, is try to provide them as much relevant information that can help them. And this is just one of these things that, when I speak to our clients, they're always talking about, and whatever that we can do as their partner to give back more than the service that they get from us, we're always looking to do. But again, I can't impress upon getting your house in order if it's not. We are a HIPAA compliant staffing company, right? You guys all know that by now. But like anything that we do, we have to know exactly what we're doing before we do it. And like what Matt said, the only reason why we are as compliant as we can be is because, we need to be to take care of, our clients. And it's also an endless journey too. So working with a company like Matt's is terrific because, I don't have to be an expert. They're the expert. So as long as I am doing what's the right thing to do, and as what Matt always tells me, reasonably acceptable, I'm doing everything I can for my company and our client's company. So again, I think anybody that's questioning it is reach out to Matt and just talk to him, and he'll answer any questions. Because I think all of this privacy, the privacy is always been a big thing. And, I don't know about you, but it's now becoming commonplace to get something in the mail, right? Saying, oh, your information is breached, and you throw it away. But that's crazy, guys. And, I know it's not exactly what we're talking about here, but the government's going to start coming on, and they're going to start tightening up what they can to give us back some of that, privacy. And you just got to get ahead of it. And like I said, if, you can do it. I mean, I've been in the outsourcing world forever. And 4 years ago, when I started in the healthcare market, I know I needed to become HIPAA compliant, and I didn't know much about it at all. But through education and through employing, Matt's firm and still employing them, like, I was able to learn just enough to be able to confidently provide the service that we do today. And like Matt says, we do it great. I still think that there's a lot that we should learn, and we're constantly being educated, as should you. But again, it's not hard to do it. You just got to do it, and you just got to get the people that are in your office to do it, because that's the most important thing. And we commit to it, and we implore our clients to commit to it, and so should you. So reach out to everybody here, like Gordon, and Zak have an amazing technology to help comply with this new, which isn't new, right? We're talking about compliance on the Cures Act. Talk to everybody you can, guys, and get ahead of this, because one day you're not going to have time. And like I said, it's not expensive. It just takes a little bit of planning, That's all I got,
Yeah.
Nathan.
No, Mike, and thank you again to Zach and to Gordon and to Matt for being a part of our show. Mike, I appreciate you affording us the opportunity to share with all of our potential clients and existing clients all of the updates in HIPAA. That's part of being the Snapscale ecosystem, guys. That's why it's important that you get involved with our content online, because we're going to here to provide you real life, tangible, practical tools in order to be able to help you grow and scale your healthcare clinic. In addition to those things, guys, this replay will be available for you. So if you're just catching in the end, you're just tuning in at the end, or if there was a certain part of the show that you really appreciated, but you had to hop off earlier and now you're just jumping back in, all those different opportunities, they're available on the replay. Just go watch the replay. All the information's there. If you missed Matt's phone number, in the replay. Okay. Mike, we're at an hour 25. I'm minute 25. Gosh, time flies when you're having fun, right? So we're at an hour 25. Thank you guys for being a part of our program today. Thank you for being a part of learning all this. Any final words, Mike?
No, just keep reading, keep protecting yourself, and keep serving patients, because we need you guys.
Patient first model. If you read any of our information, any of our case studies, you'll see we help you put your patient first. All right, guys. Thank you. Bye.